I recently started a medical malpractice lawsuit on behalf of one of my clients, and she turned around a month later and said, well, how much are we suing for? You want to know what I answered? Why I told her it's a lot different than what she thinks? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Did you know that in New York, in a medical malpractice case, when we go ahead and start your lawsuit by filing a document known as a summons and a complaint, we are not permitted by law to indicate how much money we are actually suing for. Now you may be saying, wait a second, that makes no sense. I hear all the time about people bringing lawsuits, and now you hear them saying that they are suing for $10 million, for $25 million, for $5 million. And my response to that is, yes, you are absolutely correct. But those types of cases in New York, those are personal injury cases or other cases unrelated to medical malpractice cases. In those instances, they are required, in that personal injury case, the accident case, they are required to identify how much they believe they are entitled to receive as a result of someone's carelessness. Why is it true that in New York, in a personal injury case, the injured party is required to put down an amount that they are seeking as compensation for all the harms and losses and damages they incurred? Well, the law makes a big distinction between a medical malpractice case and an accident case. They are two different legal vehicles, two different legal animals. So let's get back to the question I raised at the beginning of this video, which is, how much am I suing for? Now, the reason why we are not permitted to put a number in the document that starts your lawsuit, known as the complaint, is because ultimately the jury is supposed to decide that issue, assuming, of course, that now we get all the way to trial. If we ultimately wind up settling the case before trial, then the parties will agree amongst themselves as to the value of your injuries and what your case is actually worth. But as we go to trial, the jury will be the ultimate ones to decide how much money you are to receive, assuming, of course, they believe you are entitled to a verdict in your favor. Now, I have to share something else with you that you may not know about. You may have heard that in all these other types of injury cases, that when somebody sues for $10 million, $20 million, $30 million, you may think that that's what the injury is really worth. You may think that that's the number that the injured party truly believes they are entitled to receive. Well, I'm going to share a little secret with you. That is absolute 100% not the case. Now, I have a few other choice words for that to describe that, but the bottom line is, when they put a number down believing that they are entitled to $25 million, that does not reflect the true extent of their injuries or damages. And the reason is, if they don't ask for the sky or the moon, they're never going to get anywhere close to that. If they were to turn around and say, you know what, we, the injured party, believe that we are entitled to receive $100,000, then that is the maximum amount that the jury could ultimately give them. And there's one exception to that. But that's why attorneys will go ahead and put these outrageous numbers down in the lawsuit papers that you hear the newspapers and the news media talk so much about, claiming that things are out of control in the justice system, when in fact it's just the opposite. It is known that those numbers that are put down in these lawsuit papers are not correlated directly to the client's injuries. And again, you may be saying, I don't understand. Why don't you put down the true amount that you believe you're entitled to? Well, if you believe that you're only entitled to $100,000, then that's the maximum you can get. But what if the jury decides at trial that you, the injured patient, suffered such horrible pain and suffering and have such extensive lost earnings that now your value, the value of your injuries and your damages are worth $1 million? Well, if that's what the jury decides you should be receiving, guess what? If you and your attorney have only indicated that you are entitled to receive $100,000 at the very beginning of this case, and now the jury comes back and they don't know what you have put down in your lawsuit papers, they are just tasked with identifying how much your injuries are worth, assuming they believe you have a valid case and that someone did something wrong to cause you injury. In that instance, now you are stuck with the maximum amount that you could receive of $100,000. Now, there is one exception. After a trial, there is the possibility that your attorney can ask the judge to adjust that initial number in your complaint to reflect the full extent of your injuries and damages to what the jury has now come back with. Now, the judge could agree and raise that number. The judge could disagree and leave it at $100,000. And there could be other alternative options that the judge has, or the judge could simply say, I'm not touching it. You have a problem, bring it up on appeal. And now you and your attorney will have to fight on appeal to see whether or not an appellate court agrees with what you are claiming. So why do I share this quick information with you? I share it with you because this question often comes up where somebody wants to know, hey, how much are we suing for in a medical malpractice case? And the answer always is, we are not permitted to put a number down. And all those cases that you've heard where somebody has put a number down, guess what? Those numbers have no direct correlation to the actual damages that are being claimed in the case. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.